guys, so over the past few years, we've seen a lot of political instability in the sense that a lot of MLAs and MPs who are elected from a particular party's ticket try to change their parties during their tenure as an MLA or an MP. So this is a problematic situation, and this is not something which is going on now. This is something which has been going on for decades. Okay, so from 1967 marked the era of the coalition government in India. Okay, so from 1967 onwards, there have been a lot of cases where ministers are defecting their parties. Now, what does this mean is, wherein they leave their parties after getting elected and join some other parties. So, in this video, we'll understand the background as to how did this start and what is the law on the subject. And then we'll take a very simple example, which is very recent from Rajasthan, the tussle between the Congress leaders Ashok Gehlot and Sachin-Pilot, and understand as to how can it be dealt legally. So from 1967 to 1971, within a period of just 4 years, there were 142 MPs and more than 1900 MLAs who shifted parties after getting elected. Now, this is a problematic situation, and a lot of people called it as against the principles of democracy, and it is clearly against the principles of democracy. In 1967, an MLA from Haryana called Gayalal changed his parties thrice in a single day. So this was a really difficult situation for the parties to handle because of such ministers switching parties. The government used to fall. Okay, so now in 1985, the Rajiv Gandhi Government brought 52nd Amendment to the Constitution of India called the Anti-Defection law. Okay, now what does this mean is that any person who will shift to other party will be disqualified. So there were certain important provisions like this, as you can see. So any person who joins some other party after voluntarily giving up his membership of the party will be disqualified. Any member who votes or abstains from crucial voting as per the directions of the party will also be disqualified. In case of nominated members, if he joins the party in less than 6 months of his election or his nomination, he will also be disqualified. However, there were certain exceptions to it. So, for example, if certain people from a particular party decides to join some other party and they are 1/3 in number, so basically अगर 10 लोग किसी party के elected हैं एक legislative assembly में and 4 of them wanted to join some other party, they were allowed to do so because they were more than 1/3. However, the requirement of these 1/3 members was changed by an amendment in 2003, and right now, if 2/3 of the parties, basically 2/3 of the members of a party want to shift their parties, only in such circumstances can they be allowed to do so, and they won't be disqualified in those circumstances. Okay. Now, another thing to mention here is that how do we proceed about it? Okay. So, for example, say some MLAs or MPs defect or they leave their party. So, how will the party go about it? So, they can file a petition or some sort of a complaint in front of the chairman of the house or the speaker of the house, and the speaker or the chairman will then finally decide whether that person has defected or not. So there is some criticism of this provision in the sense that speakers generally belong to a political party that is ruling at that time. Okay, so there were allegations that speaker will be biased towards that party and so on. So in 1992, the Supreme Court in Gehlot-Pilot versus Jachilu stated that speaker will have the final authority. However, such decisions are always subject to judicial review. So basically, if you are not satisfied with the judgment, you can always move to the court, and court has the final deciding authority to finally adjudge over this matter. Also, there were certain allegations that this is a violation of the right of freedom of speech and expression of the members of parliament and the members of legislative assembly. However, the court held that for a democracy to work properly, there is requirement of such important laws such as anti-defection laws, and the government is well within its power to legislate or basically bring about such a law. Okay, so now what happens after disqualification? Okay, so obviously when a person is disqualified, he is an elected member from a particular constituency, that seat of that particular constituency remains vacant, and it cannot remain vacant for a period of say 4 or 5 years or the remaining tenure that is left now. So by-elections are held on the seats of such constituencies where seats are vacant. By-elections means that normal elections are held only to particular constituencies, and such people or basically such disqualified MLAs or MPs again have the right to contest such elections from any party of their wish. So for example, they earlier were disqualified from Congress, they can contest election from a BJP ticket later and in fact from a Congress ticket also. Alright, so that is allowed under the constitution. Now, another very important thing to understand here is the flow test. Okay, हमने बहुत सुना है news में what is a flow test. So, if the governor feels that there are certain members of the party who have defected or basically say disqualified, and even if not disqualified, they do not want to be a part of a particular party. So, the governor can always ask the chief minister to do a confidence motion, wherein he is required to satisfy the governor that his party still has the majority and they can still rule over a particular state. Basically, they are still in majority with their party and with the allies. Now, what happened in Rajasthan is, so Rajasthan has 200 seats in the state assembly. Okay, now in the 2018 elections, Congress won 107 seats, where BJP won 72 seats. And the remaining 21 seats are won by either an independent candidate or by some other small political parties in the state of Rajasthan. So, out of these 21 seats, 18 joined the Indian National Congress and BJP was joined by 3 of them. So, BJP basically had 74 seats and finally the other remaining 126 seats were of Congress. So, the very recent tussle between Ashok Gehlot and Sachin-Pilot in Rajasthan, where there were certain apprehensions that Sachin-Pilot could join BJP. Now, in what circumstances could he have done that? So, he could only do that only if 2/3 of the members of Indian National Congress, basically 2/3 of the 107 seats that they got, which is roughly 72, if at least 72 MLAs followed him. Okay, otherwise he couldn't have done that. So he could not do it because he did not have the requisite support. He did not have 72 people. And had he done it without 72 people, basically less than 72 people, there was a ground to disqualify him. This is not the only ground. We saw that there is another ground, which is when a particular person works against the party. Basically, he does not follow the party whip. Okay, so in that case also he can be disqualified. So very recently the Indian National Congress has served disqualification notices to Sachin-Pilot and his allies, and it is being contested in the Rajasthan High Court. The decision has not come yet. So this is a sufficient ground for someone who is basically working against the ideals of the parties and not voting as per the party's requirements. It is sufficient ground for disqualification. His conduct can also be considered as a ground for disqualification if he works against the party. So that's it about the session. I hope you understood it. It was a pretty simple and a small session to actually make you understand what an anti-defection law is and how an MPs and MLAs can be disqualified under certain circumstances. If you like our sessions, please subscribe to our channel and press the bell icon so you don't miss any updates from us.